Hello, everyone. Welcome to our week 11 lecture. This is our final substantive lecture for this unit, which is very exciting. Um, our kind of like week 12 lecture per se is the moot lecture, which again, if you haven't had a chance to look at it, I'd recommend taking a peek. It's in the week 12 before class materials, and this is supposed to be a lecture that kind of goes a little bit more into tips and tricks around mooting, some points around structure for your own moot as well, which we're obviously doing in week 12, which is your third assessment. So this is our final substantive topic. And I really hope that you have enjoyed the course, that you found it interesting, you found it challenging, and also seen it kind of interact, I guess, with what we're seeing in contemporaneous conflicts around the world. So I hope that it has been an illuminating time, perhaps frustrating, but in any sense, I hope that you have learned a lot and enjoyed it as well. So this week is a really important topic. It's international criminal law. It's a really big one. So we'll get started straight away. This is what we're going to try to do in the course of this lecture, as well as for your readings as well. And we'll start generally in terms of what international criminal law is, and then go more into the international crimes, and then into the courts themselves, as well as ad hoc tribunals that have been set up to deal with these criminal trials. So, international criminal law is a very important area of international law which deals with atrocities and especially war crimes, crimes against humanity, and genocide as well. So, it does build on a little bit from what we were discussing last week in terms of international humanitarian law. And it does so by particularly holding individuals responsible for these crimes. And this is different to our previous weeks where we've mostly been focusing on states. So now we're focused on individuals. And this is through a carceral system of criminal law, which means like trials, potentially the punishment of imprisonment and so forth. And most of this today is concentrated in International Criminal Court, which was established under the Rome Statute. So we're going to consider the history, nature and functions of international criminal law. We'll be focusing mostly on the core crimes in the Rome Statute. There's others, but we're focusing on like what are called the core crimes. We're also looking at the jurisdiction of the International Court too, International Criminal Court rather. And we will also have a look at some broader points around the system of international criminal law as a whole as well. So according to more our contemporary understandings, the foundations of international criminal law might be said to be based on three fundamental precepts: that international law recognizes individuals not merely as objects, but as subjects with rights and duties, which it defines, that it defines certain crimes for which individuals are liable, and that it distinguishes this criminal liability from the civil responsibility of states under international law. And so international criminal law deals with different types of violations, such as political violence, forced displacement, transfer of persons or protection of goods, which usually encompasses like cultural property, and one approach to international criminal law is to define this kind of law based on the protection of public goods and interests. So international criminal law in this sense protects individual and collective interests such as peace and security, individual and group rights or human dignity. It doesn't see them as rights per se, like human rights law, but it sets obligations on individuals vis-a-vis others. And another approach to international criminal law is more defining a crime by virtue of the nature of criminality. And this is an approach that's more popular with criminologists who have used notions to describe the foundations of international crimes. And they've viewed international crimes essentially as like state criminality, which are undertaken in pursuit of state goals and interests, and others link international crimes more broadly to a phenomena of macro criminality. So criminality or crimes conditioned by broad events that don't affect just individuals, but also societies. And then other criminologists still look at international crimes as situational crimes that are driven by specific ideologies, whether they're like nationalist ideas, patterns of victimization, dehumanization, scapegoating, absolutist worldviews, and so on and so forth. And in legal circles, there's been a strong trend to define international criminal law as mass atrocity crimes, which reflects the insight that modern conflict zones are social environments which produces cycles of criminality. And it's supposed to take into account the mandate of international criminal courts and tribunals that are mostly tied to conflict-related crimes. But this approach has also been, criticized for being too narrowly focused and failing to also include non-violent crime too. And then a third approach to international crimes more broadly is referencing the community whose interests are violated. So this relies on the assumption that a crime is an attack on like a society's normative order and whole collective conscience. And so when large-scale atrocities are committed, whether it's like genocide, crimes against humanity, or war crimes, this might be broken down to many individual acts, and many of these individual acts can be punished as like ordinary crimes under domestic law by states who are directly affected, for example. But this view sees the whole bigger than its parts, that there's actually, it's not, these mass atrocity crimes aren't just accumulations of very, small numbers, but is actually in the scope of it is standing on its own as well. So the role of international criminal law is, like I've mentioned, linked to the recognition of an individual as also a subject of international law. So it's not an individual that holds rights like human rights law looks at, as we've spoken about in previous weeks. Criminal law approaches the individual as someone who bears duties. And this idea is focused on like moral culpability of actors. And so there's assignments of responsibility and then sanctions tied to personal culpability. And this has been like a core foundation of international criminal law as a normative project as well. So it's also been a difficult contradiction in the sense where there's been a focus on the individual perpetrator, but the nature of violence is actually collective. And so this tension between the individual perpetrator and the collective nature of violence is much more pronounced in atrocity crimes, which we will see. And this was historically addressed quite famously in a historical debate between Karl Jaspers and Hannah Arendt in the aftermath of the Holocaust. And Jaspers was arguing that, you can't charge whole people with a crime. The criminal is always an individual, where Arendt supported an individual character of guilt, because if you said, if everyone's guilty, then almost no one is. So this is also kind of where the idea of international criminal law focus on the individual comes from, as opposed to like state-based crimes where, the state as an abstract entity is guilty of some kind of crime, but that also means that you can't actually hold like decision makers often individually responsible for example. So these approaches regarding this relationship between individual responsibility as well as collective criminal responsibility have developed over time. And there's different ways of viewing how these interact. And it depends on how scholars and legal theorists have viewed individuals and how they relate to atrocity crimes. One particular school sees individuals predominantly as part of a collective structure, and this is based on the belief that international crimes express the actions and the implicit guilt of an entire people. And this position kind of regards subjects as inherently shaped by the collective structures around them, such as the nation state. So you can't actually abstract individuals totally from the collectivities around them. Then a second approach starts from kind of a different view, where it sees the individual as an absolute subject, as an end in itself. And this is very much like a liberal tradition. It grounds responsibility in the choices and decision-making powers of individuals as rational, self-determined agents. It acknowledges that individuals can dominate state structures, use state powers as instruments to commit crimes. based on their beliefs and ideologies, but it still views crimes as an individual rather than a public affair. So it's quite radical in the sense of holding an individual accountable for a crime in its totality. And the idea of this is to serve indirectly as a means to ensure accountability of the crimes of the state. Right. More modern approaches and more kind of modern schools of thought, which also includes kind of, criminological studies as well as studies of, and international law academics, place greater emphasis on context. So they see individuals as social agents that are driven by certain roles or pressures, whether it's extraordinary circumstances or the interplay between the individual dispositions, broader social context, and other contingencies. They acknowledge that the international crimes committed are often embedded in social norms, political and social structures that facilitate violations as well. So we are now going to go more into the actual crimes themselves. And I mean, it's also worth just being aware that the atrocity crimes and the other international crimes that we will be talking about can be quite triggering. They're awful in their totality. They are very distressing. So just be mindful that they can be very triggering. So please, make sure you take breaks. Make sure you look after yourself. Try to unwind after lecture as well, because unfortunately, just by the nature of these crimes are very distressing. So we'll start with war crimes, which is kind of seen as like the oldest category of atrocity crimes. They are grounded in international humanitarian law, and traditionally they were also kind of associated with our jus in bello, the law of war, which we spoke about last week, which was to regulating parties in armed conflict, looking to minimize suffering and harm, which balanced those military and humanitarian considerations. So a lot of the time, war crimes were associated with the ignoring or overstepping of the balance to create suffering needlessly or indiscriminately, for example. So war crimes are seen as serious violations of international humanitarian law, but interestingly enough, and I think I maybe may have mentioned this last week, that the provisions of the Hague and the Geneva law itself don't always actually specify whether a violation entails criminal responsibility. So the war crimes law and the law behind it developed incrementally from the bases of the Hague and Geneva law, but only specific violations of this international humanitarian law are actually criminalized. Even before the development of this body of law, previously national criminal codes had tried to criminalize certain actions in war in various nation states. And since then, the Geneva Conventions and its additional protocols have then qualified grave breaches of its provisions, as we mentioned last week, as war crimes. And so we spoke about this idea of grave breaches and what it entails, which can sometimes be difficult to qualify. But what constitutes a war crime really was defined through practice in the 20th century. So after World War One, there was a commission on the responsibilities of war that identified 32 violations of law and customs of law that should be subject to prosecution. Then the Nuremberg Charter also included an illustrative list of war crimes based on the 1907 Hague regulations. But more modern ideas around war crimes were specified by the jurisprudence of the ad hoc tribunals for the former Yugoslavia and Rwanda. So in the 1995 Hague decision, which we spoke about last week, the ICTY gave a rule that to constitute like a grave crime, the violation must constitute a breach of a rule protecting important values, and the breach must involve grave consequences for the victim or victims. So when we think about war crimes, they can usually be traced back to our principles of international humanitarian law that we spoke about last week. So we spoke about those ones like distinction military necessity, for example, as well as proportionality. So these kind of things, when they are violated, and they're violated in such a way to be so severe, that can amount to war crimes, for example. So this first kind of major category of international crimes flows from our discussion last week. And this is kind of the shortest one we're speaking about because we kind of spoke about it more indirectly from the lecture last week. Now we're going to move into other atrocity crimes, which didn't come up per se specifically last week, but we will be addressing in a lot more detail here. Now, genocide is seen as like the crime of crimes. And so we are going to spend some time with it because of its kind of central place in international criminal law, the fact that it has its own convention as well, and also importantly, because accusations of genocide are animating various contemporaneous conflicts today. And probably most prominently is the accused genocide of Palestinians in Gaza by Israel at present, which was one of the interpretations of the findings of the ICJ case in South Africa versus Israel in early last year, I believe. But also, most importantly, too, that a recent UN commission has also found that genocide is being perpetuated. So it's very important to understand this crime for the modern age, unfortunately. So, as you've also probably been aware too, genocide is a very contested term. And, we'll talk about this too through the course of this lecture as well. But it's essentially an attack on human diversity, and it was initially crafted with the Holocaust in mind. But it's been used in various contexts since then. For instance, in the Khmer Rouge regime in Cambodia, Rwanda, Srebrenica, Darfur, also the attacks against the Yazidi community, in Iraq, as well as in Palestine too. But it's frequently misunderstood in terms of the social perception of the crime and the legal meaning. But like I mentioned, it is seen as the crime of crimes. Having said that, for a very long time, it was a crime that actually didn't have a name. And the crime of genocide only really had a name after it was introduced by a very famous Polish Jewish lawyer called Raphael Lemkin in 1944, who was a very, very important figure in the crime of in kind of defining the crime of genocide. And it was initially included in his work, Axis Rule in Occupied Europe. Lemkin had witnessed the Holocaust, and he used the word genocide to capture the destruction of like the foundations of the life of Jewish people in Eastern Europe. And this term, as he formulated it, was a combination of the Greek word geno, so a tribe or a race, and the Latin word caedre, so to kill. So it's certainly most likely butchered that as well. But this combination genocide is like, to kill an entire race. So the essence of the crime is the destruction of the cohesion and moral dignity of groups which are classified as collective entities, as an element of some kind of like international society. So Lemkin referred to destruction in the holistic sense as well. So not just of people, but of destruction of political and social institutions, culture, language, national feelings, religion, and even economic existence. So one of the distinctive features of genocide is that groups are attacked for being rather than for doing something. And Lemkin managed to persuade the prosecution to include it in the Nuremberg indictment under the crimes against humanity. But in the Nuremberg judgment itself, genocide was not specifically mentioned at this time. So the Holocaust was punished under the notion of crimes against humanity, which included persecution and extermination. But the reason that the term genocide wasn't used here was because it was a very new crime, as it was newly defined by Lemkin, very importantly. There was also reluctance at this time, especially in European history, to deal with victim groups rather than individuals. But after Nuremberg, Lemkin campaigned for the universal prohibition of genocide, following on from the genocide of Jewish people in the Holocaust. And Only a year after the Nuremberg judgment, the UN General Assembly adopted a resolution that affirmed that genocide was a crime under international law, which was unprecedented and spoke to the historical significance of the Holocaust and genocide as the crime of crimes. And it was defined in the UN Convention on the Prevention and Punishment of the Crime of Genocide, which was orientated very much towards the criminalities that occurred during the Holocaust. Having said that, that it was a narrow scope, and that was advocated by Lemkin himself. But the convention is special in several ways. It doesn't only contain a very early reference to a project of international criminal jurisdiction before there was actually any international criminal jurisdiction, and it included structures of state responsibility. In addition to emerging ideas of individual criminal responsibility. So, and importantly, it had a duty of states to prevent genocide. And this was a really important article that expands also past the parties or countries who might be directly affected. But this convention was not actively used for quite a long time. And many lawyers early on in the 1950s argued that or even saw the convention as a registration of protest against like past misdeeds of individual savagery rather than an effective instrument of prevention and repression, which was more of a insight into expectations perhaps around that time that such a crime wouldn't happen again. But unfortunately, by the end of the 20th century, that was already shown to be wrong. And following the actual convention itself, the international criminal courts and tribunals were the ones that actually brought the concept of genocide to life. The definition of the convention of genocide was reproduced in the statutes of the international criminal courts and tribunals like those that were dealing with Yugoslavia and Rwanda, and they adjusted the definition to new contexts. So in terms of going through the elements now, we'll first start with the material element. So according to Article 2 of the Genocide Convention, as well as reproduced in Article 6 of the Rome Statute, genocide means any of the following acts committed with intent to destroy in whole or in part, and we'll come back to that later because that's an important distinction, a national, ethnic, racial or religious group as such. So this means killing members of the group, causing serious bodily or mentally harm to members of the group, deliberately inflicting on the group conditions of life calculated to bring about its physical destruction in whole or in part, imposing measures intended to prevent births within the group, forcibly transferring children of the group to another group. So this material element of genocide may take the form of any one of these five prohibited acts directed against any one of these alternative protected groups. And noting some of the points of controversy or the points of debate and points that often need definition when these crimes come up in these international criminal tribunals. The first one is, well, how is a protected group defined? And this framing has continued to spark controversy as well. So the Genocide Convention, as we mentioned, was drafted against the background of the horrific experiences of World War II, but international law was still in a very rudimentary stage. And so it wasn't very sophisticated at that time. States and the drafters didn't really contemplate all types of genocidal patterns that leaders might use against citizens and members of their own societies. Because in many modern cases, atrocities have involved mass killings by one part of a national group against another group, or a segment of the same group in a different area. And in these cases, it's been difficult to determine whether they're targeted as members of a national group as such and thus protected, or because of some other criteria, like their status maybe, or membership in a political group, maybe in economic or professional groups. And so this designation and determination of who's protected posed dilemmas in relation to the qualification of the acts by the Khmer Rouge in Cambodia, for example. And in this case, In Cambodia, the majority of victims were members of the Khmer majority population. But these members were targeted because of their belonging to a specific political, professional, economic class. And the UN rapporteur at the time coined a new term, auto-genocide, to distinguish this act of a government against its own people um, from the acts through which a regime targets a group which is considered as an other, such as the killing of the Jewish population and people of Slavic origin by Nazi Germany. And so this Cambodian case is qualified as a genocide under a broader reading of this protected group environment, which gives or qualifies certain subgroups as protected parts of national groups, or uh, give or at least defines this list of protected groups non-exhaustive, or places an emphasis on the result of the crime, that there's a destruction of some kind of some kind of group of people in whole or in part. Um, and even in the Rwandan conflict, determination of group identity was also a problem. So the Tutsi population didn't objectively constitute a group as per a strict reading of the Genocide Convention. They spoke the same language as the Hutu. They shared the same religion. They also had a common cultural identity. And the International Criminal Tribunal for Rwanda determined ethnicity in light of the political, social, and cultural context. Um, and it recognized that collective identities, and in part ethnicities, or really in particular ethnicity, are not social facts, but actually social constructs that are dependent on perception. And so this helped the jurisprudence shift around this idea, and it moved gradually from an objective understanding of ethnicity, and this was often grounded in very racist notions of science, where you could categorize people under certain ethnicities based on biological factors, for example, towards a combination of more objective and subjective elements. So in this case, it was found that an ethnic group, and I'm quoting here, is one whose members share a common language and culture, or a group which distinguishes itself as such, so a self-identification, or a group identified as such by others, including perpetrators of the crime. So if it's identified as like an other group by others. So it's therefore this idea of a particular group is considered not only perception, but also self-perception, as being self-recognized. So the court here recognized Tutsi as a separate ethnic group because they were treated as such in official classifications. They also perceived themselves as distinct too. And this reflected also a sentiment in the Security Council, which had actually made the resolution that founded the instruments of the tribunal as well. And importantly, too, in this tribunal as well, it acknowledged that sexual violence, too, also could be a means of committing genocide. And the Genocide Convention acknowledges that acts such as sterilization or forced procreation may amount to genocide, but it didn't deal with the systematic sexual violence and the systematic rape that was seen in that particular conflict and others as a means of committing genocide in the sense of destroying a group. So in the Akayesu case, Akayesu case, it found that rape and sexual violence constituted a form of such serious bodily and mental harm that leads to the physical and biological destruction of Tutsi women, families, and their communities. And this is especially so when there is an intent to commit sexual violence upon women to impregnate them with children belonging to another group. So this case, Akayusu took a commonsensical approach to an interpretation of genocide, which also shaped subsequent rulings and also shaped the place of sexual violence in genocide as well. So now, turning our minds to the mental element, there's really two mental elements for the legal definition of genocide. The first is an intent to execute one of the underlying offences of the material element. But the most distinctive part of genocide, or the feature of it in terms of the mental element, is the second one, which is a more stringent mental element of a specific intent of the perpetrator to destroy in whole or in part a protected group as such. Now, this is important too, this distinction around in whole or in part, because genocide does not require the actual destruction of a protected group. But the acts, according to the convention, must be committed with the intent to destroy the group in whole or in part. Now, this is quite difficult to prove. Now, historically, again, going back to the very important historical figure of Lemkin, he saw the intent requirement as a tool to facilitate the prosecution's case in situations of emerging patterns of violence. So actually before the large-scale loss of life occurs. And I think this is also a really, really important point that is often missed in broader social discussions of genocide. Most definitely the mainstream media discussion of genocide is that the whole idea of the Convention against Genocide, as well as the crime itself, as it was or I guess named and thought about and founded as such by Lemkin, was that it's not actually something that applies after the fact. It is supposed to be a crime which you can see it happen before it actually does. So the idea of Lemkin was actually this intent can help us discern emerging patterns of violence before any large-scale loss of life occurs, so it can be stopped. Um, so this requirement, however, and when it then got into international law, it turned into quite an onerous subjective requirement. And it needed demonstration or some kind of evidence of an intent against a listed group or a protected group to destroy them in whole or in part. Now, again, going to one of our ad hoc tribunals, the ICTY in Yugoslavia, the former Republic of Yugoslavia, they developed many modern aspects of modern genocide law. It didn't struggle so much with the determination of ethnicity or group requirements, as was the case in Rwanda, but its main innovation was adjusting the interpretation of genocide to different contexts, and in particular, like how killings and destruction against parts of groups in quite limited geographic areas, such as enclaves and towns, could also be genocide. And it very firmly put down that genocide was not a game of numbers. Okay, it had absolutely no relation to how many people had been killed. And so at the ICTY, practice started with cases against mid or low level defenders. One of the early cases, it may have actually been the first, the Jelicic case, was quite an atypical one. So Goran Jelicic was a 23-year-old commander, a very young commander in at the Luka camp in Bershko, which was and he was partly deranged, and he presented himself as he called himself, a Serbian Adolf, as in Adolf Hitler. He claimed to hate Muslim women, and he entered a guilty plea for war crimes and crimes against humanity, but he failed to acknowledge genocide. Now, the trial chamber in the Jelicic case acknowledged that genocide may exist, even when the exterminatory intent only extends to a limited geographic zone, such as a region or municipality. The main problem was that Jelicic's crimes were not directly part of a broader Bosnian Serb policy to destroy the Bosnian Muslim population in Breko. And the genocide charge deviated clearly from the logic of the Holocaust. It was not grounded in actual objective factors, such as the mass killing carried out according to some kind of, specifically put down plan or policy. But the question was whether the intent of the person alone can amount to genocide, even in the absence of a backing state or institutional policy. So it went to the heart of the nature of genocide, whether it could be judged by objective or naturalistic features of crime, or even just by the intent of the perpetrator. And so the approaches here is that the first one is how you could then address this question is thinking about, well, and this is more relevant, I guess, to like investigation and prosecution, where investigators or prosecutors could look first to evidence that crimes were committed and then try to analyze, well, what's the relationship of the defendant to the crime? And according to this kind of logic, it must first be determined whether genocidal acts have occurred. And then it's assessed, well, did that person act with genocidal intent? And this approach is grounded in a historic vision of genocide, that it's an exceptional crime and it's distinct from crimes against humanity. But a second approach, which is more unorthodox, it determines individual criminal responsibility, and which can be supported by objective factors, which, for instance, can be a plan or policy going beyond the individual agent. But it also includes consideration of the subjective intent of the accused. So a single criminal act, so a single murder, perhaps, for example, may actually amount to genocide if it's carried out with intent to destroy. Um, so this understanding is not excluded by the plain wording of the convention, though it contrasts with like social understandings of genocide, maybe the popular understanding of genocide, you might call it, or even in mainstream media, which tends to focus on objective events, how many people were killed, for example, rather than criminal intent. But this second, more unorthodox approach is actually one which is much better reflective of Lemkin's initial understanding of genocide. And importantly, in Jelinek, the International Criminal Tribunal for the former Yugoslavia leaned towards the second understanding. And it noted that the mens rea, which gives genocide its speciality and distinguishes itself from an ordinary crime and other crimes against international humanitarian law, is this way of looking at intent. But in this particular case, even though taking that more unorthodox understanding, they couldn't find that kind of intent in that particular case, the Jelinek. But it did hold that the convention doesn't discount the possibility of a lone individual seeking to destroy a group as such, because the drafters of the convention didn't deem the existence of an organization or a system serving a genocidal objective as a legal ingredient to the crime. And then in the appeals chamber, this point was affirmed as well, because it held that the evidence couldn't have provided for the basis for a reasonable chamber to find beyond a reasonable doubt that the respondent had, the intent to destroy the Muslim group in Breko. But even though it was like an early case and it wasn't a particularly overly famous case, the Jelinek case was important because it kind of pointed towards a methodology of establishing genocide. So it focused on that the question around genocide is not whether a particular set of crimes can be labeled in the abstract as genocide, but whether the accused person is responsible for genocidal acts, even if they don't amount to huge numbers of people being killed with genocidal intent. So the ICC then also has a additional material element, which requires that the conduct must take place in the context of a manifest pattern of similar conduct directed against a group, or a conduct that could itself affect such destruction. And this is a very specific threshold to the ICC. And it was introduced to reflect the special gravity of genocide and to avoid isolated hate crimes falling within the ambit of ICC jurisdiction. And it was also a reaction to Jelinek. And so it was trying to limit the kind of cases that could reach the ICC because the ICC has a much wider jurisdictional mandate. Now, in terms of another controversial or certainly much spoken about issue in terms of defining genocide, is it's quite unclear in the convention what in part means. Destroying a group in full or in part. It has been a question. What does that mean? And again, what we might call a popular reading or a broad maybe mainstream reading might be that a genocidal policy involves a total extermination. Thousands upon millions of people. But again, one of the innovations that ICTY did was extend the protective scope of genocide through a more dynamic and fluid approach to the construction of genocidal intent, which again reflected Lemkin's initial concerns. And it ruled, importantly, the ICTY in another case ruled that destruction of a part of a group is sufficient if it's like an emblematic of the overall group. And this finding was most related to the case relating to Srebrenica, which differed from the systemized and massive group destruction that characterized the Holocaust. And the key case here was that of Christic. So the appeals chamber used very strong wording in this case, and it affirmed the need to call the massacre at Srebrenica by its proper name, genocide. And Christic made several key contributions in terms of the case to the interpretation of genocide law. Importantly for our discussion at the moment, it clarified like a geographical scope of genocide. So the court here in Christic accepted the argument that genocide may occur even when the exterminatory intent extends only to a limited geographic zone, something that's been called localized genocide. So the size of the Bosnian Muslim population in Srebrenica amounted to only like 40,000 people prior to its capture by forces of the Republic Srpska, which was the Serbian-backed entity. This number was just a fraction of the small percentage of the overall Muslim population of Bosnia at the time. So Christic acknowledged, in terms of the court acknowledged that the importance of the Muslim community of Srebrenica is not captured by just its size, and it noted that by seeking to eliminate a part of the Bosnian Muslims, the Bosnian Serbian forces committed genocide. They targeted for extinction the 40,000 Bosnian Muslims living in Srebrenica, a group which was emblematic of the Bosnian Muslim population in general. And this, again, is compatible more with this victim-centered framing of genocide, which was very famously promulgated by Lemkin. But it also reduces the concept of genocide to small parts or units of a broader group. That means that a destruction of a subgroup, and for instance, in this case, it was the destruction of military-aged Bosnian Muslim men mostly, could then be emblematic of a broader destruction of a group. Okay, so this destruction of a part of the group could then amount to genocide. Now, the last kind of point here, which is another point of difficulty, is inferred intent, because, and I mean, we've spoken about intent generally, but it's obviously very hard to establish because it's difficult, just like in your normal criminal law cases. You can't see into the mind of the perpetrator. Now, in the case of the Holocaust, the intent could actually be quite plainly shown by Nazi documentation. But in modern context, this has become more difficult in some capacities. So the case of Christic at the ICTY accepted that genocidal intent may be shown through circumstantial evidence. And it's mostly inferred from circumstances such as, and this is quoting from the case, the general context, the perpetration of other culpable acts systematically directed against the same group, the scale of atrocities committed, the systematic targeting of victims on account of their membership of a particular group, the repetition of destructive and discriminatory acts, or the existence of a plan or policy. So quite a broad idea of intent. And based on the historical assumptions, some scholars still maintain that genocide requires evidence of some kind of state policy. But tribunals in practice have clarified that it's not actually strictly required by the text. A focus on a state plan or policy may imply then that non-state actors cannot commit genocide, which is, of course, would be a ridiculous narrowing of the convention. And especially because the whole convention is supposed to protect and stop genocide even before it happens. It's important that the tribunal has moved past this focus on just state policy, for example. Now, in the Holocaust and Rwanda, the killing of women and children were used as an argument to support the establishment of genocidal intent. Whereas the context of Srebrenica, the order to kill related only to the destruction of around 7,000 military-aged men and boys in Srebrenica, only in the context of a much larger, broader Muslim population. But the prosecution there argued that the intent to kill the men and boys was to eliminate the community as a whole. So this sense of destruction is further than biological or physical, um, and it was claimed that the community broadly may survive in the biological sense, but nothing more. And the prosecution argued it's a community in despair that's clinging to memories, a community that's lacking leadership, that's a shadow of what it once was. And the Krestic judgment argued that there was a combination of factors which was geared at the destruction of the group. And the judgment had three main arguments. So, firstly, and this goes towards intent, the Bosnian Serb forces could not have failed to know that their selective destruction of a group would have a lasting impact on the entire group. Their death precluded an attempt by the Bosnian Muslims to recapture the territory as well. And secondly, too, the Bosnian Serb forces had to be aware of the catastrophic impact that the disappearance of basically 2 to 3 generations of men would have on the survival of a traditionally patriarchal society. And third, the combination of those killings with the forcible transfer of women, children, and the elderly would inevitably result in the physical disappearance of the Bosnian Muslim population at Srebrenica. So these are our points on intent. And those cases that RCTY are important to keep in mind when thinking about intent for the crime of genocide. Now, genocide is also not just a crime based on the biological elimination of the people, and we've already kind of hinted at that through our discussion so far. And there has been a really long discussion in the academic literature as well as in the jurisprudence as to whether cultural destruction can amount to genocide. And cultural dimensions do play an important role in these kind of determinations. Because the acts of genocide are actually not confined to just killing. So the cultural factors, such as like social, historical, and linguistical features, are often necessary to explain whether a group actually qualifies as a protected group. So, whether it's racial, ethnic, religious, or national group, or, through other definitions, as we spoke about in the tribunals around Rwanda. So the physical and biological destruction actually usually always goes with the elimination of cultural features, property, symbols, academic institutions, education, means of actual, economic livelihoods, these kind of things. And again, this is relating very strongly to Lemkin's idea of genocide, which I keep coming back to because it's really important. That genocide is not just the physical destruction of a group. It's not, and not just the elimination of its reproductive capacity, but includes attacks on cultural institutions. So this is the systematic destruction of language, religious institutions, education, for example. And early drafts of the Genocide Convention actually contain references to national cultural genocide. But at this time, there was a lot of criticism whether this cultural idea of cultural genocide was concise and grave enough to warrant criminalization under this crime of crimes. And then other states also were worried that their own acts against their minority and indigenous populations in terms of cultural destruction would then act to genocide, and they were very keen for that not to be the case. And so it was only covered to a limited extent in the drafting itself. And the Genocide Convention does speak to some of those parts of cultural destruction when it talks about, intending to prevent births within the group, which obviously relates to biological destruction, but also the social structure of the community. Also, in terms of forcibly transfer of groups' children, which speaks to the forced exposure of children to another culture's language and culture itself, which can alter the future existence of a group. So it is within the subtext there, but is not potentially explicitly stated as such. And also the destruction of cultural monuments or other kind of acts directed against the culture of a group may be used as evidence to support allegations of physical genocide, or even as a crime against humanity as well. So it's indirectly enshrined in the uh, convention, the Genocide Convention, but it being not being there explicitly so more reflects the political constraints of treaty negotiations rather than the actual reality as the crime. Now, moving on to our next point here, which is our words as bullets. This is referring to incitement. And genocide is the only crime in which incitement is expressly prohibited. So this prohibition takes into account that genocide is often spread through mass mobilization. So at Nuremberg, Julius Streicher, I think is pronounced his name, was the editor of a viciously anti-Semitic magazine, and he was convicted for hate propaganda against Jewish people. So his incitement to murder and extermination was qualified as persecution as a crime against humanity. So the drafters of the Genocide Convention criminalized this public and direct incitement of genocide to counter emerging patterns of genocide and take into account the specific risks of incitement of an indeterminate group of persons. And this was really important in the Rwandan genocide as well. This public incitement was a central factor. The tribunal of Rwanda here tried the first incitement to genocide cases, and it adapted a really broad interpretation. So it looked at speech delivered through classic channels, as we might call them, which is like loudspeaker, radio, or media, to a large and often indeterminate audience. So the first case here, which we already mentioned kind of in a different context, was Akeyisu. And Akeyisu was tried for giving a speech that called for the elimination of Tutsi, and he referred to them as Inkotanyi, which I think is a term something relating to something like cockroaches or similar, but it was in reference to Tutsi. So it couldn't be shown in and of itself that the speech triggered genocide because the killings had already started elsewhere. But the chamber found that incitement is such a crime that it has to be punished as such, even when the incitement actually fails to produce the results expected. So even without the results, just the incitement itself should be criminalized. And then the tribunal went on to define the contours of the crime. So it said that the person who is inciting must have specific intent to commit genocide. Again, the underlying crime doesn't have to actually be committed. So the causation is not a legal requirement to prove the crime of incitement. So this justification for this lies again in the preventative purposes and the potential for communication to cause genocide. And this incitement is deemed to involve such a high risk for society that it's punished irrespective of whether the genocide occurs. But it did clarify, the tribunal did clarify the public element may be satisfied if it calls for criminal action to a number of individuals in a public place or to members of the general public. So this directness requires provocation rather than just a mere vague or indirect suggestion. And what the tribunal looked at was, well, what was the intended impact on the recipient and the intended that was meaning to be conveyed, which is also understood in light of the context as well. Now, the paradigmatic case, the fundamental case, Akeyusu was an early one, but the fundamental one was the Rwandan media case. And this concerned the responsibility of news media groups in the genocide. So it had three defendants who were charged as representatives of different media entities, and they broadcast ethnic stereotypes to promote hatred for the Tutsi population. They, for instance, dehumanized Tutsi as cockroaches. They, and had lots of other characterizations of them. And this decision broke new ground because it held a newspaper editor and even a broadcast executive criminally accountable for the crime of not only of actually what they said, but the crime their words did as well. And so in this case, the trial chamber analysed the euphemisms and found that certain of them were amounted to incitement. And it said that the defendants deployed speech as a weapon. That created this violent and dehumanizing social environment through these kind of statements. And they clarified that it required this crime of incitement, a calling on the audience to then take action. And it used four different points to look at this, which I won't go into any detail whatsoever, but just said that they have to look at the purpose of the incitement, the text, the context, and also the relationship between the speaker and subject to then classify whether it's incitement. So now this is our long discussion on genocide, which again, I think is an important crime to go into in some depth. And we're going to now move on to crimes against humanity. So this concept of crimes against humanity does capture some features of genocide and with it the idea of extermination. But unlike genocide, it's not actually codified in an international convention. And its origin again lies in the humanitarian principles governing armed conflict, which we have spoken about last week. And it's kind of seen as protecting individual legal interests such as liberty, autonomy, and human dignity. So while genocide focuses on the collective nature of the victims as a group, crimes against humanity tends to penalize the collective nature of the perpetration of crimes. So crimes against humanity are attacks on civilian populations that are at risk because of their presence in the targeted population. So the idea is that the crime is no longer an ordinary crime under domestic law, but now an international crime where the collective action of an organization causes harm to the civilian population, which reaches a threshold of widespread or systematic violence. So in terms of the nature of these crimes, this is also something that is based in history. So previously, and as we've spoken about before in different contexts, the conduct of states against their own citizens was previously a matter of internal affairs. And importantly, after World War II, the Nuremberg trial broke with this, but also had important limitations as well. And it basically said, crimes against humanity against your own population couldn't be charged independently of some kind of nexus or connection to other crimes. They had to be linked to some kind of war crimes or crimes against the peace, that is, basically warfare. So the fact in this case that the Nazi crimes were committed as part of an unjust war served as one of the major justifications for the Allied jurisdiction, which is why they connected crimes against humanity to warfare. But after that, in the later part of the 20th century, that idea of crimes against humanity having to be connected to some kind of war was kind of broken. And because the reference to the concept of civilians in the definition of these crimes against humanity, sorry, made basically made the crime appear like as if it was linked to war crimes, right? But as the human rights tradition kind of started developing more and more by the end of the 20th century, this concept also developed as well. One of the really excellent books that I read very early on in my legal career, or even my legal studies, was the book Crimes Against Humanity by Jeffrey Robinson, which I would really recommend, which kind of goes into this history in a lot more detail. He looks at key cases which he's involved with, and I think it's a really fascinating book, which I thought was quite inspiring early on for me. And yeah, that book goes into this kind of history, but with the development of the kind of human rights movement, this idea of crimes against humanity was actually a dynamic kind of category of crime that was kind of a bit more fluid than other ones which were more codified. So these crimes against humanity were included in the statutes of like the International Criminal Court, the tribunals of Rwanda and Yugoslavia, and based on their recognition under customary international law. And it was the ICC statute that had the most comprehensive modern treaty codification. And the criminalization of it occurred in an incremental way. It sought to fill the gaps in international domestic legal systems. It concerned crimes that protected different interests. But yeah, there was a lot of justifications to kind of the broader develop of this area of law. And much of it was based around the idea of trying to um, uh, categorize these crimes as concerning a broader interest rather than just the victims themselves, but an interest of humanity, which again is very indeterminate, quite elastic, but and that kind of helped crimes against humanity be very dynamic and change, be almost relatively what was called a chameleonic, like a chameleon, like it changes its colors as needed for the situation. And there's a couple of different theories that kind of thought about, well, why that was the case. And one of the theories around crimes against humanity that they are international crimes is because they present that attack on humanity as a collective and the quality of the individual as a human. So they're prohibited because they target the victim's humanity and common qualities that all humans share. A different theory looks more at peace and security. And it argues here that crimes against humanity are international offenses because they threaten the entire peace and security of the world. And that was reflected in Nuremberg and the Yugoslavian tribunal definitions, which was then fit with the rationale to limit the jurisdiction of international courts and tribunals to the most serious crimes. Whereas a third theory thinks about the essence of these crimes against humanity in terms of the right of individuals to be protected from abuses of power. So it's generally seen that crimes against humanity are essentially about abuses of power from misuses of authority. And a more modern, maybe understanding, as you might call it, is that the policy element needs to be understood in a broader sense, that it's covered not only by states or state-like entities, but also other organized entities that direct, instigate, or encourage crimes. So crimes against humanity can be committed in the context of armed conflict and in peacetime as well. The essential element that distinguishes crimes against humanity from domestic crimes is their context. So they're usually related to a social system of oppression and domination. They must be committed as part of a widespread or systematic attack against the civilian population. And this notion of attack is understood in a wide sense. It's not just armed force, but any form of mistreatment. And it can be denunciation, it can be discrimination practices. The civilian population, though, must be the primary object of the attack. And this kind of collectivity of civilians, they must share kind of some kind of distinctive features that mark them as targets of the attack. And so if the attack is widespread, is conducted on a large scale, results in a large number of victims, but there's no specific numerical threshold. The courts and tribunals look at factors such as the consequences of the attack upon target population, as well as the number of victims as well. But it does also have to be systematic. So there has to be an organized nature of the act of violence, like a repetition of a similar criminal conduct on a regular basis might be shown by a plan involving attacks. It might have indicators such as the existence of a policy or an ideology to destroy or weaken a community, discriminatory measures, whether it's discriminatory laws or measures that seek to change demographics of populations, and also the involvement of political and military leaders in the establishment of some kind of plan as well. Now, the example of the gradual modernization of crimes against humanity is the approach towards crimes of sexual and gender-based violence that have been developed in an unprecedented manner in the last number of decades. And the history of this too, it's a really obviously a very terrible history, but in classical warfare historically, women were always seen as some kind of spoils of conflict. And even after World War II, there was a lot of uncertainty as to whether, sexual and gender-based violence could be prosecuted as a separate substantive crime on its own merits. And sexual violence was really a major blind spot in Nuremberg and also the Tokyo trials. And the Tokyo trial was silent on the sexual slavery that was suffered by the so-called comfort women who were used en masse by Japanese forces that was used across where they were occupying. And the Nuremberg Military Tribunal also didn't expressly prosecute sexual violence either. Um, and even the Geneva Conventions, which we spoke about last week, also has failed to recognize sexual violence as a grave breach. They qualified the rape and other acts of sexual violence as attacks against the honor of women or their personal dignity, which is also problematic in itself. And feminist scholarship has criticized the lack of attention to women's experiences in the conception of international law, even since the end of the Cold War. Ad hoc tribunals have defined gender crimes such as rape and sexual enslavement in a more modern fashion, in a way in response to these critiques. And going back again to the Akayasu case, this was the first signature case which established that express connection between the use of sexual violence and the political motives underlying an identity-based conflict, which was important because it was the first international trial judgment which defined rape and sexual violence, and then started bring more gender sensitivity to jurisprudence. And interestingly enough, in this case, the prosecution actually didn't bring charges of sexual violence. And the reason or the part reason for this was the assumption that the victims were unwilling to come forward because of the stigma attached to the crimes, the fear, and also the evidentiary difficulties that to create a link between the acts of sexual violence and the accused. But it was actually the bench that moved the prosecution to include charges for rape as a crime against humanity and inhumane acts. And the trial chamber found the Akayusu guilty of crimes against humanity of rape, and added that, and I'm quoting here, sexual violence was an integral part of the process of destruction, specifically targeting Tutsi women and specifically contributing to their destruction and the destruction of the Tutsi group as a whole. Also the chief prosecutor of the Special Court for Sierra Leone also integrated charges of sexual and gender-based violence into virtually all indictments, even also using novel paradigms such as forced marriages as well. And then at the International Criminal Tribunal for the former Republic of Yugoslavia, nearly half of the indictments contained sexual violence charges, and more than 30 people were convicted by the ICTY for crimes involving sexual violence. And then kind of in this context, the ICC statute contains quite an extensive list of sexual and gender-based violence. So it's treated not just a specific form of cruel or torturous treatment, but actually define the offences in and of themselves. And it expressly captures sexual violence, and it codifies forms of reproductive violence as well for the first time when it was written. But obviously, the prosecution of sexual and gender-based violence faces many challenges. And importantly, in terms of the history of the ICC, in early 2016, the ICC entered its first conviction relating to sexual violence. Jean-Pierre Mbemba, who was a former Congolese vice president, was found guilty for rape as a crime against humanity and a war crime. And the trial chamber convicted him due to his failure to prevent or punish such crimes as a military commander. And his conviction also included, importantly, the crime of sexual violence against men, and not just women, in terms of cases of rape as well. And Bemba was originally sentenced to 18 years for rape. Having said that, on appeal, this conviction was actually overturned, but it didn't have a lot of a detailed consideration of the rape or sexual violence investigations. It's still this kind of fight to include sexual and gender-based violence still has quite a long way to go. So this is our crimes against humanity. Our next and final kind of international crimes we'll look at is that of apartheid. And this is seen as kind of an anomaly on the list of crimes against humanity. It's criminalizing actually a particular structure and a system of oppression and racial discrimination. And it does have synergies with genocide. It's a term which has particular stigma and especially historical heritage and connected to the struggle of decolonization. And its criminalization goes back to the Cold War era, and especially on the adoption in 1973 of the International Convention on the Suppression and Punishment of the Crime of Apartheid, or the Apartheid Convention. And this convention was targeted at stigmatizing racial discrimination. And it specified that the crime of apartheid shall include similar policies and practices of racial segregation and discrimination as practiced in Southern Africa, and in particular the apartheid regime in South Africa. And this convention had many innovative features. It had a reference to criminal responsibility of members of organizations and institutions, the exercise of universal jurisdiction based on custody over the accused, and the establishment of an international tribunal with jurisdiction over the crime, which echoed elements of the Genocide Convention. So it made it impossible for later drafters of conventions of the ICC to ignore the special nature and gravity of apartheid as a crime, although the convention itself very much received divided support. Just 1 second, please excuse me. Cat troubles. Hello, everyone. This is Shams, and he's very sorry that he keeps interrupting Dada's lectures. Okay, there you go. All right, sorry. So as I was saying, the importance of and just make sure I am actually recording. Yes, the importance of the Apartheid Convention was that it forced drafters of the of the ICC to also include it and consider it as a crime. But it was very controversial. And in the drafting of the ICC statute, it was controversial as to what extent apartheid should be recognized as a specific crime. And it wasn't included in the list of war crimes, but it overlaps with other categories of crimes against humanity, namely persecution on racial grounds and other inhumane acts. And it's included as a crime against humanity in Article 7. Now, the definition of apartheid in the ICC statute differs partly from the Apartheid Convention. Some states voiced concern that the extension of apartheid beyond the South African context would be problematic, and much of this was that there was concerns that it would criminalize racist views or policies of radical private actors, basically white supremacists. And the statute then specified that the apartheid requires conduct committed in the context of an institutional regime of systematic oppression and domination by one racial group over other racial groups or groups. The reading of this still remains very contested. Some argue that this framing captures mainly discriminatory practices by a state against members of its own population or polity. And this analogizes with the South African precedent. It implies that the unique stigma and distinction of apartheid from other forms of prohibited discrimination, like persecution, is because it's built on a state sanctioned regime of law, policy, and institutions, whereas other voices defend a broader interpretation of this concept of like an institutionalized regime. They argue that the term regime refers more to a method of a system of organization and captures institutionalized practices by non-state acts, also including de facto policies by armed groups as well. So apartheid is generally framed as a specific intent crime. The perpetrator must commit a prohibited inhumane act with the intent to maintain such a regime. So it captures usually and mostly the responsibility of leaders and organizers. Doesn't usually capture those actors who don't have some kind of control. the biggest issue, in a sense, is the way or how the crime of apartheid can be separated from its historical context. Um, but the ICC statute does extend it beyond the South African context, though states have been very reluctant to prosecute apartheid as a crime against humanity, despite the wide jurisdictional provisions of the Apartheid Convention. And the main example where the modern analogy has been made is the situation in the Palestinian occupied territories. And Palestine has made this argument in its submission to the ICC, and it's argued that Israeli policies constitute an institutionalized regime of systematic discrimination that deprives Palestinians of several of fundamental human rights, which is also supported not only by large sections of the scholarly literature, but also by the 2024 advisory opinion by the ICJ last year. And this issue was enunciated by the court where, and this is the ICJ now, in the advisory opinion last year, where the court found, and I quote here from paragraph 229, that the court observes that Israel's legislation and measures impose and serve to maintain a near complete separation in the West Bank and East Jerusalem between the settler and Palestinian communities. And for this reason, the court considers that Israel's legislation and measures constitute a breach of Article 3 of the Convention of the Elimination of All Forms of Racial Discrimination. And this article reads, state parties particularly condemn racial segregation and apartheid and undertake to prevent, prohibit, and eradicate all practices of this nature in territories under their jurisdiction. So this particular finding by the court, which cited Article 3 of the Convention of the Elimination of All Forms of Racial Discrimination, which talks about, and this again, that article talks about racial segregation and apartheid. This finding led some academic and scholarly and legal commentary to suggest that, yes, the court had reached a finding of apartheid. But Article 3 refers to racial segregation and apartheid. So breaching that could refer to racial segregation, apartheid, or both. And this is seen in the separate opinions of their honours, some of which considered that a finding of a breach of Article 3 was that of apartheid, and then others believing that the court hadn't made this finding. But the ICJ advisory opinion had held Israel to be in violation of this Article 3, and it could be interpreted either way to whether it's a finding of apartheid. It still shouldn't be of any doubt that it's a very significant finding, which is at the very minimum a finding of racial segregation. So this is now our discussion of international crimes. And I know we've been going quite a lot. This is, as you can appreciate, a really gigantic and an important area. But we're now going to turn more towards the actual courts themselves. And I'll try to do this relatively quickly as best I can. I'll try to go through the main and important points. So the outside of the ICC, there are other, and we'll talk about the ICC in some depth. There are many different and important ad hoc tribunals that have been created. Now, we've already been referencing quite a number of these, there has been a lot of talk, especially in the 90s, and action in establishing ad hoc tribunals. So in the early 1990s, the Security Tribunal the Security Council had created a tribunal that had a jurisdiction confined within the frontiers of the former Yugoslavia after it had, as it was kind of breaking down, and it was going to prosecute offences that began in 1991. And then in 1994, the Security Council also voted to create a second ad hoc tribunal, which was charged with prosecution of genocide and other serious violations in Rwanda, as well as adjacent countries too. And so these were both important tribunals, which again, the jurisprudence here is vital for our understanding of international criminal law, which we've already highlighted a number of important cases here. Now, in 1994, the UN General Assembly decided to pursue work towards the establishment of International Criminal Court. And it envisioned a statute, or actually, it really used the draft. There was a draft statute which had been written by the International Law Commission, which it used to create the statute for the ICC, and it required 60 ratifications for entry into force, and it entered into force on the 1st of July 2002, which is important to know because the court can't actually prosecute crimes committed before then. And this entry into force also began the real formalities of actually, establishing the court, such as the election of judges and the prosecutor. States were also invited to sign the statute, which was a preliminary step to, indicate their intention to ratify. And they were given to the end of 2000 to do so, and 139 states did. Even states that voted against the statute at the Rome Conference, where it was also being debated, such as the United States, also ultimately decided to sign. So that number of 60 ratifications was reached on 11th of April 2002. Then we had a new international institution which exercised in a field that had previously been occupied in a sense by the Security Council, and the Rome State Statute was an attempt, which had created the ICC, was an attempt by many states to kind of do indirectly what they couldn't do directly, which was kind of reform the United Nations and amend the Charter. So it was kind of seen in a way as a challenge to the Security Council, and especially the difficulties of the veto vote, and especially this time is mostly the United States. And it also contributed to understanding the early success of the organization. It was a bold and exciting challenge, as was seen at the time, to existing mechanisms at the UN. And so there was a lot of states enthusiastically joining it. And so it had the kind of newness, the enthusiasm around it, and the particular powers it had created kind of like some excitement around the court itself. However, one of the important points was that the United States didn't become a state party, and there's an interesting history here, and it's obviously very important to be aware of the relationship between the ICC and the United States, because that still plays out today and has a significant impact on the work of the court, as the United States being the world's major superpower. When the statute was being finalized, one of the final acts of the Clinton administration was to sign it. Right at the 11th hour, just before it was kind of like agreed. Now, the Bush administration, which came in after, and only the Bush administration only came in like a few weeks after the Clinton administration signed the statute, was very hostile to the court, and took the really unprecedented step of approaching the United Nations Secretariat to revoke its signature. And the international law didn't actually contemplate an unsigning of a treaty as such, but the Vienna Convention on the Law of Treaties did envision a situation where a state could change its mind. And in Article 18 of the Vienna Convention, a signatory state may not defeat the object and purpose of the treaty prior to its entry into force until it has made clear its intent not to become a party to the treaty. And this is what the Bush administration did. They filed a communication with the UN Secretary General and effectively unsigned it. And this was only a first step in increasingly aggressive challenges to the court. And much of this took the form of measures aimed at protecting what the United States euphemistically referred to United States peacekeepers. And the United States pressured a large number of states to reach bilateral agreements, whose purpose was basically to shelter American nationals from the court. So made agreements with other nations, which said, we won't send American nationals to the ICC. And so the ICC could not get an accused because in Article 98 of the ICC statute, in the Rome Statute, the court's prevented from proceeding with a request to surrender an accused of a country if it would require the requested state to breach an international agreement that it made with another state, such as agreements that some countries had made with the United States. And so the American diplomats had bullied more than 100 states, and half of them not even parties to the statute, whose obligations were irrelevant, to sign these kind of agreements. But worse was kind of yet to come. Within a few days of the statute's entry into force, the United States announced it would veto all future security councils that concerned peacekeeping and collective security operations until the council adopted a resolution that would basically exclude members of these operations from the jurisdiction of the court. And the United States threatened to withdraw peacekeeping troops from East Timor if they didn't have immunity, and this blackmail actually succeeded. And then President Bush signed into law the American Service Members Protection Act. And this act prohibited agencies of the United States government from cooperating with the court. It imposed restrictions on its participation in United Nations peacekeeping activities. It prohibited U.S. military assistance to states parties to the statute and authorized the use of force to free any U.S. citizen who was detained or imprisoned by or on behalf of the court, and it has been named euphemistically the Hague Invasion Act. And even though, a few years later, the Obama administration warmed ever so slightly to the ICC, the opposite effect certainly happened with the election of Donald Trump the first time round, and especially during the second iteration of his presidency. So the prosecutor of the ICC when Donald Trump was president of the United States in his initial presidency, the prosecutor was going to investigate allegations of torture by Americans in Afghanistan and Eastern Europe. And this created a huge amount of confrontation with the United States. And in 2018, the White House said that if the court were to proceed with such an investigation into American activities, the administration would consider lots of different measures, which would include, more agreements with other nations to stop any surrendering of United States nationals to the ICC, and the White House at this time also said that they'll ban ICC judges and prosecutors from entering the United States, sanction their funds in the United States financial systems, and prosecute them in the United States criminal system. And then in 2019, there was visa restrictions announced on personnel of the International Criminal Court who were involved in investigations of US personnel. And he also said, and this was Mike Pompeo, the US Secretary of State, who made this pronouncement. He said that this policy of investigating United States servicemen might also be used against allies, which is why they came down so hard on the ICC at this time. And the court's prosecutor's visa was also revoked, which prevented them from traveling to the United States. And there was also, more recently, of course, this has then kind of expanded into the maximum amount of pressure, which, as you can tell from this short discussion, has been building over a long range of time to what we're seeing today, where the United States has adopted a profound range of sanctions and penalties against the ICC, its prosecutor, and its staff in response to the court filing arrest warrants against Israeli Prime Minister Netanyahu and also Israel's former Defense Minister Gallant for crimes against humanity and war crimes against Palestinians in Gaza. So the kind of corollary or the opposite to this very difficult and tortuous relationship between the ICC and the US is the early, very enthusiastic support for African states, which had been seen as quite a surprise in the early years of the International Court, International Criminal Court. When it was being created, many participants kind of harbored a North-centric understanding through which the court's membership would rest on developed countries, but its sphere of activities would be in the developing world. And Africa was seen as the kind of, I guess at this time, the poster child of states who are either unwilling or unable to bring perpetrators of atrocities to justice. And these arguments were featured in favoring a court with universal jurisdiction because it was believed that the states where international justice was required would never actually participate in the Rome Statute. And it was also contended that there should be a low number of states for entry into force of the statute, because most states on the planet, including troublesome states, would never join, as it was thought. However, one of the surprises was that in Africa, where again it was seen that most of the court's jurisdiction would initially be, this perspective was actually totally wrong. There were certainly some exceptions, but many African states embraced the court. Even those with ongoing conflicts at the time, and by the early 2000s, nearly 26 African states had ratified the Rome Statute. So this African support was really vital, actually, in enacting the Rome Statute. And the prosecutor of the ICC focused cases initially in Africa, and they focused on prosecution of criminals in Africa's really persistent conflicts around the Great Lakes regions. There was self-referrals from Uganda, the Democratic Republic of Congo, and the Central African Republic, which demonstrated the willingness of many African states to actually allow the court to address their problems. But this kind of feeling changed when the jurisdiction was triggered not by initiatives from the African states themselves, but by the UN Security Council. And one of the examples of this was the 2005 referral of the situation in Darfur by the UN Security Council, which didn't initially provoke difficulty. Prosecutor of the ICC moved slowly. His first targets were quite low figures in government and some of the militias, but the issue started to quickly formed ahead when, in mid-2008, the prosecutor announced their decision to prosecute the president of the country, Omar al-Bashir. And the African Union's request that the court back off were dismissed, because it was seen by the court and other critics as a self-serving, autocrats kind of looking out for themselves. But this was kind of the start of a lot of African states losing a lot of trust in the court. And really until early 2016, when the prosecutor was looking at the situation in Georgia, all 9 active situations at that time were in Africa. So when the prosecutor decided to investigate the situation in Afghanistan, the pre-trial chamber sat on this application for a really long time, like a year and a half, because it was looking into crimes of Western countries, and then rejected it. And so all the accused had been African before 2022. And so it was really hard to deny that it looks like an old colonial court, which is mostly run by Europeans, like 70% of course personnel are European, and with a jurisdiction of 120 territories. Like pretty much all the cases now are focused on Africa. And it's only been with the arrest warrants against Russian President Vladimir Putin and Maria Lvov-Belova, as well as Israeli Prime Minister Benjamin Netanyahu and former Defense Minister Yoav Gallant. This represents somewhat of a new page in the history of the ICC, where the court is actually pursuing allegations of war crimes against non-African states. And as such, in response to this, the court has faced unprecedented backlash from powerful Western countries, no more than the USA, like we have mentioned, especially for its filings against Israeli ministers, who are obviously a key Western ally. Now, the last few points we'll go through, and I know I've been going through quite a lot already, is just looking at the jurisdiction and admissibility of the ICC, which are really important points. And jurisdiction, identifies the scope of the court's authority. Article 5 is titled Crimes Within the Jurisdiction of the Court and has a list of punishable offences. Article 11 it says Jurisdiction Ratione Temporis, which just means like temporal jurisdiction. Article 12 is preconditions to the exercise of jurisdiction, which sets out what is more, really it's not really reflected by the title, but it sets out territorial jurisdiction and personal jurisdiction. Then Article 19 requires the court to satisfy itself that has jurisdiction in any case brought before it. And it's important to also keep in mind that ICC was created with the consent of those who are themselves subject to its jurisdiction. So they agreed the crimes committed on their territory or by their nationals may be prosecuted. And this is fundamental of the court's jurisdiction. It's the jurisdiction that the international community has accepted for the ICC is narrower then the jurisdiction that individual states are entitled to exercise with respect to similar crimes. And the drafters of the Rome Statute actually sought to limit the ability of the court to try cases of which it has, at least in theory, some kind of jurisdiction. And importantly, too, the drafters, and this is reflected in the Rome Statute itself, requires that the state's own courts, have a go first at trialing criminals. And it's only when the domestic system is unwilling or unable, then can the ICC actually step in. And this is what is referred to as complementarity in the statute itself. Now, in terms of temporal jurisdiction, the court cannot exercise jurisdiction over crimes committed before the entry into force of the statute, and so it differs a lot from its predecessors. Previous international criminal tribunals were actually established, after the fact, dealing with crimes committed before they were created. So this is quite unique for the ICC in terms of other criminal courts. And it's Article 11, subsection 1 of the Rome Statute that says the court has jurisdiction only with respect to crimes committed after entering into the force of the statute. So that's the 1st of July 2002. The statute also kind of deals a little bit with this issue in Article 24, which declares that no person shall be criminally responsible for conduct before the entry into force of the statute. And in the case of states that become parties to the statute after its entry into force, the court has jurisdiction over crimes committed after entry into force of the statute with respect to that state. So, for example, Colombia ratified the statute in August 2002, several weeks after its entry into force on the 1st of July 2002. The statute only entered into force for Colombia later in the year, in November 2002. And so the court cannot prosecute any cases that are based on the Colombian ratification for the period between the 1st of July and the 1st of November. But it doesn't exclude it acting with respect to crimes committed in Colombia during that period, but the court must establish its jurisdiction on some other basis, like if the perpetrator is a national of some other state party, or the situation is referred to by the Security Council. There's an exception to the general rule concerning this temporal application, because a state can make an ad hoc declaration recognizing the court's jurisdiction over specified crimes, even if the state is not a party to the statute. And this is done under Article 12, subsection 3 of the statute, which kind of appears like it's kind of retroactive. And so Uganda made such a statement in 2004, where it accepted the exercise of the court's jurisdiction for crimes committed following the entry into force of the statute of 1st of July 2002. This appeared to be accepted also by the court as well, where it accepted crimes in Uganda prior to Uganda actually accepting the jurisdiction per se. And similarly, Cote d'Ivoire, or the Ivory Coast, ratified the Rome Statute in 2013, but it had a declaration in 2003 that it reconfirmed in 2010 that ensured that, similar to Uganda, the court could exercise jurisdiction over acts perpetrated before becoming a state party. And also similarly, Palestine made a declaration under Article 12, subsection 3, giving the court jurisdiction from June 2014. And this was almost a year before the statute entered into force, following its accession in early 2015. Now, in terms of the personal jurisdiction, the ICC exercises jurisdiction over nationals of a state party who are accused of a crime. And this is Article 12, subsection 2b, regardless of where the acts are perpetrated. So the court can also prosecute nationals of non-party states that accepts jurisdiction on an ad hoc basis by virtue of some kind of declaration, or pursuant to a decision of the Security Council. Now, in terms of territorial jurisdiction, the court has jurisdiction over crimes committed on the territory of state parties, regardless of the nationality. And this is in Article 12, subsection 2a of the statute. It also has jurisdiction over crimes committed on the territory of states that accept its jurisdiction on an ad hoc basis, as well as where jurisdiction is also conferred by the Security Council, which is also important. Now, territory for the purpose of the criminal law jurisdiction is often a term that needs to be defined. It extends to land, but it also refers to territory committed on board vessels or aircraft registered in the state party, for example. And this is a now widely accepted extension of the concept of territorial jurisdiction. So in the case, which was called the Gaza flotilla situation, and this is not referring to the current or flotillas happening this year, but that of 2010, the Turkish Gaza flotilla, the alleged crimes that occurred on board vessels that were flagged to three state parties, which were Cambodia, Greece, and Comoros. Although the acts themselves took place in the high seas or in the territory of Israel, which is a non-party state, then they were also captured by the territorial jurisdiction. And also, territorial jurisdiction should logically extend to the airspace as well. But these are also some kind of grey areas too. Now, in terms of, and kind of in addition to territorial and personal jurisdiction that results from ratification of the statute with respect to state parties, Article 12, subsection 3 also contemplates the possibility of a non-party state to accept the jurisdiction of the court on an ad hoc basis. And this is Article 12, subsection 3. And this requires a state to lodge a declaration, to accept a jurisdiction, and this is like an accepting state. So an example of this is Ukraine, which remains a non-party state, has formulated two declarations pursuant to this article. In early 2014, it recognized the jurisdiction of the court for the purposes of identifying, prosecuting, and judging the authors and accomplices of acts committed in Ukraine within the period of late 2013 to early 2014. This was during the Revolution of Dignity, where Yanukovych, the Ukrainian president, got kicked out by a revolution in Ukraine, and that's when the war in Donbass also started. And then Ukraine filed a separate declaration in mid-2015, which also covered a period before after the 22nd of February 2014, which has sought to cover crimes committed during the war on Donbass. And similarly as well, Palestine has formulated declarations pursuant to Article 12, subsection 3 as well. Now, the subject matter jurisdiction, last point of jurisdiction we'll talk about here, is that ICC has jurisdiction over four major categories of crimes: genocide, crimes against humanity, war crimes, and the crime of aggression. And these are described in Article 5 and the preamble. These are the most serious crimes of concern to the international community as a whole. And we've discussed these already, so I won't go into them in any kind of detail. Now, the triggering mechanism, which is Article 13, this says that the court can exercise this jurisdiction with respect to a crime referred to in Article 5, which is those crimes I just briefly mentioned, in accordance with the provision of the statute if there's a situation where one or more of such crimes appears to be committed, is referred to the prosecutor by a state party, a situation where a crime is being committed and is referred to the prosecutor by the Security Council, acting under Chapter 7, or the prosecutor has initiated an investigation in respect of such a crime in accordance with Article 15. And so there has to be one of these three conditions where the prosecutor can then actually start a investigation. So it can be referred by state, by Security Council, but the prosecutor can also conduct their own preliminary examination. They can receive communiques as well from anyone to help them start an investigation as well. And so when the prosecutor conducts a preliminary examination on their own initiative, this is called proprio motu. And so when the prosecutor acts proprio motu, or motu perhaps, without a referral by a state party or the Security Council, they have to establish this investigation on a reasonable basis. And then they have to get authorization from a three-judge pre-trial chamber or a pre-trial division if it's a case of aggression. But this authorization isn't required by a state when it's a referral by a state party or Security Council. So this is also important to think about this triggering mechanism. Now, our last point here is admissibility. as I think we're hopefully coming to the end here. The ICC can have, our jurisdictions covered. It can have temporal, territorial, personal, and subject matter jurisdiction over a case, but it'll only decide to proceed, and it may decline to proceed if the case is being investigated or prosecuted by a state, or it's being prosecuted, or because it's not of sufficient gravity. And this is admissibility. It involves a bit of discretion by the court, so it's not obliged to assess whether a case is admissible if the prosecutor and defense do not contest the matter. And the court may examine admissibility of a case on its own initiative, even if it's not raised by one of the parties. The court must address the issue still of jurisdiction, even if the parties, do not raise it. Now, the admissibility procedure applies to all cases that come before the court, even if it's referred to by the Security Council. So it's really important always for the court to think about admissibility. But the line between jurisdiction and admissibility is not always super clear. And so provisions in the statute, the Rome statute, that seem to address one or both or other of these concepts appear to also overlap quite a bit. In one of its jurisdictional provisions, the statute talks about the court has jurisdiction over war crimes, in particular when committed as part of a plan or policy or as part of a large-scale commission of such crimes. But when it's in a provision that deals with admissibility, the court is empowered to refuse to hear a case that is not of sufficient gravity. So the implication of these two provisions, where one is addressing jurisdiction, the other admissibility, may be a bit comparable, and the court will decline to prosecute less serious or relatively minor crimes. And the most important of the components of admissibility is complementarity, where the court will not proceed if the case is being addressed by domestic jurisdiction. Also another one, that of gravity, has been generally more insignificant, although it does take on important elements in terms of prosecutorial discretion. And then another one that the court, another reason that the court won't proceed is that the accused has been prosecuted for a crime already, but this kind of rarely happens. Now, complementarity is the most important, and this is where the state has already started, investigating, and the statute, then the ICC can't step in. But the Rome Statute has a framework to determine if the national justice system is unwilling or unable genuinely to proceed. And with respect to the inability, Article 17, subsection 2 says that the court can consider whether the process of the national jurisdiction or the proceedings was actually to shelter the offender. So nations can't just start kind of pretend domestic proceedings without any real intent to prosecute someone properly, or if they've been unjustifiably delayed, just to basically keep out the jurisdiction of the ICC. So the court can step in those cases, even if there is a ruling ongoing, if it's not a genuine one. Even if if there is a inability for the national judiciary to prosecute the particular person, or if there's a total collapse or unavailability of the judicial system, then the ICC can carry out its proceedings. So this is an important consideration, that of complementarity. Early on, this didn't really, wasn't really that significant, but it has become an increasingly important determination. And this is where states most often challenge the court on the grounds of admissibility, where states have said, look, we've got our own adequate justice system. For instance, one case with Kenya, Kenya put forward, we have our own case of our justice system for these people who are accused, and the court rejected it, holding that these domestic investigations were not directed actually at the important senior leaders who were named in these particular arrest warrants, because Kenya at that time were just dealing with lower level perpetrators, and Kenya was like, we will get there, but the ICC denied that was the case. There's also a case maybe only admissible if the state is unwilling or unable to investigate or prosecute. The ICC has also kind of said that this can be the case if the state is inactive. So there's kind of different ways in which the ICC thinks about this. And to determine whether a state is unwilling, there's kind of three main factors that are thought about. So it's firstly that the proceedings of the decision not to prosecute in the domestic context were made to shield the person concerning criminal responsibility for crimes within the jurisdiction of the court. There's an unjustified delay in which the circumstances is inconsistent with an intent to bring the person concerned to justice, or proceedings were not or are not being conducted independently or impartiality. And this is all under Article 17, subsection 2 of the statute. And there's different forms of unwillingness as well, which the court in its jurisprudence has gone through. So the other point just to note as well as we come near the end is that of gravity. So Article 17, subsection 1D states that a case has to be, sufficient gravity to justify action. This is usually a reasonably insignificant article because the nature of the crimes are usually just, prima facie significant and sufficiently grave. And this has also been borne out in a lot of the jurisprudence here that because the crimes in and of themselves, being war crimes, crimes against humanity, they're always usually going to be of a sufficient gravity. But it's still important just to be aware of these points of admissibility. So, team, I think that is now it. And that is our last lecture for this semester. Again, I'll get you please to look at the video I made in week 12 before class for your moot. I look forward to our final in-class or online tutorials this week. We'll hopefully again be doing some good learning while having a bit of fun with the activities I've designed. One of them will be a little bit of a modification of something we've done already to make it relevant to the ICC. Another one will be something that is brand new and exciting, I hope. So I look forward to seeing you all there, and thank you so much for tuning in once again.